Imagine a world where your favorite movies and gadgets hinge on bitter legal showdowns over invisible tech rights. It's happening right now, and it could redefine how we stream and communicate. In this clash between entertainment powerhouse Paramount and laptop maker Acer against telecom giant Nokia, patents are the battlefield, and the stakes are sky high for innovation and fair play. But here's where it gets controversial. Are these lawsuits genuine protection of intellectual property, or aggressive tactics to squeeze competitors into unfavorable deals? Stick around, because most people miss the nuanced details behind these patent wars, and we'll break it down step by step to make it clear even for beginners. Let's dive in and explore how this drama is unfolding across continents. We're talking about streaming technology here, that backbone of modern entertainment that lets us binge-watch shows on demand. To put it simply for those new to the concept, streaming tech involves compressing and transmitting video data efficiently, often relying on patented methods like HEVC, high-efficiency video coding. This allows high-quality videos to load faster on your devices without gobbling up all your data. Nokia, a leader in telecom standards, claims Paramount and others are infringing on their patents in this space. But now, Paramount and Acer are pushing back with their own legal strikes in Europe, turning the tables in a dispute that's already raged in places like Brazil and the United States. Picture this: Paramount, the studio behind blockbuster films and TV hits, isn't taking Nokia's global lawsuits lying down. They've shot back with a lawsuit in the United Kingdom, filed under case IDHP 2025-000055, accessible via caseboard.io at https://caseboard.io/cases/0297dbcd/453-4C55-B8-1F2622C03B6-9. Nokia kicked things off in October by expanding their patent battles to Europe, including claims at the Unified Patent Court, UPC. That's a specialized court system in Europe designed to handle patent disputes more efficiently across multiple countries, simplifying what used to be a patchwork of national courts. For beginners, think of the UPC as a one-stop shop for patent fights, avoiding the hassle of suing in every single European nation separately. On Nokia's side, a crack team from IP litigation firm Arnold Ruess has been leading the charge. Key players include Cordula Schumacher, Arnold Ruess, Tim Smentkowski, Jan Werjin, Tuggs Alton, and Victoria Thussing. They've been joined by patent attorneys Christoph Walk and Lars Graneman from Cohose and Florac, who are no strangers to advising Nokia on such matters. This team is handling the offensive claims, targeting Paramount's use of video streaming tech. Defending Paramount at the UPC and in Germany is a squad from Hogan Lovells, featuring Benjamin Schroer, Stefan Steininger, and patent attorney Andreas Schmid. Interestingly, Hogan Lovells' UK team isn't part of these active suits, which is a detail worth noting. It shows how legal strategies can get compartmentalized by jurisdiction. Meanwhile, Paramount's offensive move in the UK is being handled by a team from Kirkland Ellis, known for their prowess in patent litigation. Paramount's side of the story comes straight from a spokesperson, who emphasized, Paramount respects intellectual property rights and takes allegations that it uses the intellectual property of others seriously. In August 2025, while licensing discussions were ongoing, Nokia took the unfortunate step of suing Paramount in multiple venues around the world. Many of these lawsuits seek injunctions in an attempt to coerce Paramount to take a license on unfair terms demanded by Nokia. As a result, Paramount has filed an action in the United Kingdom to seek a determination of reasonable and non-discriminatory terms for a license to Nokia's HEVC patent portfolio. Paramount does not take this step lightly and believes that the determination of the English court will lead to a fair resolution of the parties' licensing dispute. To clarify for those unfamiliar, an injunction here is like a court order that could stop Paramount from using certain tech until they agree to license terms. It's a powerful tool in patent wars, often criticized as a way to bully smaller players. And this is the part most people miss. While licensing talks were happening, Nokia jumped straight to lawsuits, potentially bypassing negotiation. Is this standard practice in the tech world, or an overreach? It sparks debate on whether patent holders should be able to weaponize courts this way. But the drama doesn't stop with Paramount. Taiwanese computer giant Acer is also in the ring, countering Nokia with lawsuits at the Munich Regional Court. Acer's claims focus on EP 2,451,225. Check it out at https://register.org/application?number=EP111875996 under case ID reference 2101398925. A patent related to wireless communication technology. For beginners, this patent likely deals with how devices connect wirelessly, perhaps improving data transfer in laptops or routers, essential for seamless online experiences, like downloading apps or streaming without interruptions. Nokia, meanwhile, has its own active lawsuits against Acer at the UPC, centered on video coding patents. They're suing based on EP 2,661,892, viewable at https://register.org/application?number=sign EP127319727 in the UPC, and also over EP 2,375,749, https://register.org/application?number=sign EP111703771, and EP 2,274,375, https://registered.org/application?number=sign EP097435334, at the Munich Regional Court. Nokia's not picking favorites. They're also targeting Asus and Hisense with the same trio of patents, showing a broader offensive in the consumer electronics space. Representing Nokia in these UPC battles is a team from Bird & Bird, led by Christian Holmsen, Nick Pearson, and Tobias Wilk. At the Munich court, defending against Acer's claims, Nokia has Boris Kray and Lars Hessmann from the same firm, a consistent choice, as they also handled similar cases against Oppo, highlighting how legal firms build specialized expertise. On Acer's end, they're backed by a team from Taliens, including Thomas Linker, Christian Werner, Evelyn Hofer, and Thomas Reithman. The active claims for Acer were filed by a group around John Peters from Casalonga, rounding out this web of legal talent. As this story unfolds on November 27, 2025, penned by Christina Schulze, it captures a snapshot of high-profile patent disputes, with Nokia, Paramount, and Acer clashing in multiple jurisdictions, as illustrated in the stock image by Diego Adobe Stock. But here's another controversial twist. In a world where tech evolves rapidly, should patent holders like Nokia dictate terms, or should courts enforce fair and non-discriminatory licensing to keep innovation open? And is suing for injunctions a fair game, or does it stifle competition by pressuring companies into lopsided deals? We invite you to share your thoughts. Do you side with the patent enforcers or the challengers? Agree or disagree with Paramount's push for judicial fairness? Drop your opinions in the comments below, and let's discuss.